Good afternoon. Welcome to our online series, A History of Security Fraud Scandals. We're really excited about this one. I'm going to just briefly highlight some upcoming events that we've got for the Society. On January 11th, we're going to be joined on an online series, A Geopolitical Update, with former U.S. Ambassador to Germany, John Emerson. He's going to touch on current and future geopolitical issues. On January 26th, we have our 19th annual forecasting event, which is going to be featuring Dennis Lockhart, Rick Reeder, and Barbara Reinhardt at the Cobb Energy Center. Again, that's January 26th from 5:30 to 8:30. And then finally, upcoming as well, we're going to talk about the other side of the issue on ESG investing. Hot button, this one probably will get some interest, is ESG investing a violation of fiduciary duty? But for the main event, we're joined today by James Park. He is professor of law at the UCLA School of Law. He is an expert on corporate law and securities regulation. After graduating from Yale Law School, Professor Park worked for federal judges and practiced law in New York City at a law firm, and then as an assistant attorney general in the Investment Protection Bureau of the New York State Attorney General's office. If you could, please submit your questions via the Q&A feature within the Zoom controls at the bottom of your screen. And with that, I'll turn it over to Jim to begin. It's great to have you.
Thank you so much, Robert. It's great to be here. I also wanted to say thank you to Kathy Ford, who set up this webinar. Thank you all for coming today. As a lawyer, I'm always happy to have the opportunity to speak to non-lawyers. And the book I wrote on the history of securities fraud regulation is on a topic I think that is of broader interest than to legal professionals. As Robert mentioned, I am a law professor at UCLA, where I teach securities regulation. I started in practice about 20 years ago, this past fall, just a few months after the passage of the Sarbanes-Oxley Act of 2002. Enron had filed for bankruptcy late in 2001. That was followed by the WorldCom collapse in the summer of 2002, and that was essentially the precipitating factor for the passage of Sarbanes-Oxley. I spent some time as a defense attorney for a couple of years in New York City, defending companies and individuals against SEC investigations and private securities litigation. Then switched sides and went over to the public sector and worked for New York Attorney General Eliot Spitzer for a couple of years in the Investor Protection Bureau, bringing cases. And so that really sparked my interest in the subject of securities fraud. And when I became a law professor, that's where my research has really focused on. And so this book is the culmination of about 20 years of thinking about the problem of public company securities fraud. So let me share my screen with you. So when we planned this webinar a few months ago, we could not have predicted that just a couple of days ago, we would see the filing of criminal charges against the founder of FTX, the largest cryptocurrency exchange, which suddenly filed for bankruptcy about a month ago. And there's still a lot we don't know about what happened, although we now have the SEC's complaint. But the basic allegation or claim is that the exchange basically misappropriated customer funds, and an affiliated hedge fund used those customer funds to speculate on various crypto assets. And when those crypto assets started declining in value, we have a company that became insolvent very quickly. And there's a potential billions of dollars that have potentially been misappropriated from customers. And that's why there is a criminal case that has been brought against the founder. In addition to just garden variety theft and fraud, there are allegations of securities fraud brought by the SEC as well as the federal prosecutors, because FTX raised about $2 billion from various institutional investors, and there were misrepresentations made about the company and its practices, its compliance with law, And so there's also a securities fraud here that we see. And while FTX is a private company, and we're seeing more of securities fraud in private companies, my presentation is mostly about public corporations, public companies, and how they may commit securities fraud. So there are quite a few books that look at maybe one or two securities frauds. Some of you may have read Smartest Guys in the Room about the Enron fraud. Bad Blood on the Theranos fraud is also a great read if you have a chance. And so what I wanted to do, though, is I wanted to write a book that looked at major securities frauds over time, that would be able to compare and contrast various epic frauds that are representative of their time period. And so by looking at multiple frauds, my hope was to get a better sense of how securities fraud works and how the regulation has evolved over time. By securities fraud in this particular context, I'm referring to the very particular problem where a corporation, a public corporation with stock that's trading in public markets, issues some sort of misleading information or misrepresentation to the public in order to inflate its stock price. There are a lot of different types of securities fraud, such as insider trading. My main focus, though, is on public company fraud, because I think it poses special problems for regulation. The Sarbanes-Oxley Act, as I mentioned, was passed around when I first entered practice. A very important law, a law that has also been controversial to some extent. And the criticism is that the measures it requires, the assessment of internal controls on a yearly basis, various corporate governance measures, these provisions arguably make it more expensive to be a public corporation. And there have been some criticism of laws like Sarbanes-Oxley and Dodd-Frank because they discourage companies from going public and entering the public marketplace. And my take on this, though, is that the need for Sarbanes-Oxley is evidenced by the problem of public company securities fraud and the pressures on public corporations to commit securities fraud. If you look at the issue of securities fraud over the last 30 or 40 years, its evolution, my argument is that there are certain pressures that are inherent in being a public corporation that necessitate certain structural measures that public corporations should be required to adopt in order to prevent securities fraud. Interestingly, in about 40, 50 years ago, securities fraud was not seen as a problem for large public corporations. Securities fraud was seen as mainly an issue for smaller companies that may not have been subject to the disclosure requirements of the securities laws, maybe newer companies that are just startups with new products that don't have the money to invest in internal controls. This is a report, a page from a report by the SEC, a special study of securities markets published in the 1960s, where the SEC comes to the conclusion that 93% of the frauds that it discovered were by private companies, companies that were not reporting under the securities laws. Larger public corporations at the time were seen as not needing to commit securities fraud because they were so powerful. They essentially had monopolies in their core businesses. And so they didn't really have an incentive to commit securities fraud. They could invest in internal controls. They had well-trained managers who were versed in the new science of management, who could basically manage their company through any significant problems. And so this was not seen as really a problem for larger public corporations. So what changes? What we see over the 1960s and 1970s is that methods of valuing public companies begin to evolve and change. And this happens to some extent as we get more institutional investors entering the marketplace as opposed to retail investors. Institutional investors were investing more in the stock market, and they were basing their decisions on fundamental value, information about the company's financial performance. And so we see in the same SEC report a note about the emergence of research analysts, which are ubiquitous now and quite familiar to all of you. Some of you may be research analysts, but these analysts basically started sort of becoming more prominent as institutional investors became more prominent. And one of the things, as you know, analysts do is they come up with predictions of a company's future financial performance, and that's reflected in this particular excerpt from the same report. The core of almost all recommendations is the projection. And part of the thesis of the book is that as projections become more ubiquitous, we see more pressure on public corporations to meet those projections, to show that their future earnings and their future prospects are strong. And that's the valuation treadmill that my book is referring to, the need to continually meet projections and evidence strong growth for the stock market. So why do public companies commit securities fraud? That's one of the takeaway points or lessons of my book. And I think there are really a couple of major simple explanations for the motivation for securities fraud. The first bucket of securities frauds that we see tends to involve a company that is growing and trying to create the impression that their growth is strong. And in order to keep meeting projections of strong growth, they may misstate their earnings or issue other misleading information. Another category of securities fraud involves public companies that were once prosperous and strong, but they find that their business is declining for some reason. They're facing pressure as their business is not as strong as it used to be. And so oftentimes these companies will commit securities fraud in order to try to hide that decline from markets, in order to give managers some time to turn the company around and perhaps recapture some of the former glory of the company. So one example of a public company that committed securities fraud to show that it was growing and a strong company was a company that was located about 10 minutes from my office here at UCLA, the Equity Funding Corporation of America. It was an insurance company. And basically what it did was to increase its sales, its revenue. It made up insurance policies that it claimed to have sold to people who did not exist. They had a separate office in the Beverly Hills area where they had a staff whose job it was to literally create files of fictitious people so that when the auditors came knocking, they had these files they could show the auditors. At a somewhat early stage of the fraud, the auditors came and they couldn't come up with about 40 of the files. And so that was a lost opportunity where the auditors might have asked some follow-up questions and discovered that, you know, the reason the 40 files were not there is they did not exist. They had to be quickly made up and then provided to the auditors. To make matters worse, Equity Funding reinsured the policies. They ceded the risk to other insurance companies, reinsurers. And what this did, though, is it obligated Equity Funding to provide turnover premiums in future years to the reinsurers. And the problem is that these customers did not exist. They were fictitious, which created a need to make even more fake insurance policies. So why did they do this? This was in the 1970s, and the bankruptcy was big news at the time. This is a fairly sizable New York Stock Exchange traded company. And the bankruptcy examiner said in this report, this is basically a securities fraud. They were trying to inflate and keep aloft the market price of their common stock. And this is something fairly new for large public companies in the 1970s. This was a shock to the system that a company like this could engage in such a bold fraud. The CEO of the company was begged by his management team to stop doing this. We're all going to go to jail if we keep making up these fake insurance policies. He rejected such proposals, though, because a leveling of reported earnings would adversely affect the market price of the common stock, a prospect he would not entertain. And so this is where we first see the pressure of this valuation treadmill on a large public corporation that was trying to create the impression of strong growth. We also see in the 1970s a major example of a company that committed securities fraud in order to hide its decline. Penn Central was the nation's largest railroad. It had been created a few years before its bankruptcy through the merger of the New York and Pennsylvania railroads, iconic corporations that had been around for about 100 years, seen as very safe investments, blue chip stocks, widows and orphans stocks that were really reliable. The merger was criticized by some because the combined entity was perceived as being too powerful, but the merger was also a sign of substantial weakness. Railroads are facing more competition in the 60s and 70s. The interstate highway had been started and partly completed during the Eisenhower administration. We also have cheaper air travel at the time. And so the core business of rail travel was facing significant pressure. And so Penn Central, in order to hide its decline, would often sell assets that it had accumulated in better times when it was a more prosperous company. They had a lot of land in New York City, owned part of Madison Square Garden, the New York Knicks, New York Rangers, various sports teams, assets all over the country. And many of these asset sales were not problematic from the perspective of securities fraud, but there were a handful, though, that went over the line, that should not have been recorded as sales. And one of them involved a Six Flags amusement park. I think it was in Texas and maybe Arizona. And so basically they sold the Six Flags amusement park to a partnership of investors. And normally this would be a sale that you could count as revenue that might have offset some of the losses from the railroad business. The problem was that there were these side agreements, side arrangements that Penn Central had with the partnership, that Penn Central would keep the risk of loss. And so if the value of the Six Flags park declined, Penn Central was obligated to make up the losses to the partnership. And so that's not a sale. A sale requires the transfer of the risk of loss to the purchaser. To the extent that Penn Central is keeping that risk of loss, it cannot recognize that revenue as a sale. This is very similar to what Enron did decades later. So we often see patterns here of similar types of accounting manipulations by public companies. What did Enron do? It had special purpose vehicles run by its CFO, Andy Fastow, and Enron would sell various assets that it wanted to keep off its books to those SPVs and often recognized revenue that was counted in its income statement. So this was an improper sale, but the auditors defended it. What was their defense? They said, well, it might have been improper, but it was not material. It was only $29 million, which is a small amount for a company worth more than $1 billion. And as you may know, if a misstatement is not material, it does not trigger liability under the securities laws. And auditors generally do not look at immaterial sort of events or transactions in putting together the company's financial statements. An accounting professor, Abraham Brilloff, who was a professor at Baruch College in New York City, wrote an interesting response in Barron's. And what he said was that, well, you're missing the point. The materiality has to be linked to the fact that it allowed Penn Central to meet a projection. Penn Central had predicted that it was going to be profitable for the year. Without this $29 million transaction, Penn Central would have reported a loss instead of a small profit. And so this is an example of the growing influence of projections as metrics that had to be met. And misstatements were often used to meet projections. And this was viewed by the SEC as a type of material misstatement that would support an allegation of securities fraud. So we're beginning to see this in the 1970s. Another type of securities fraud involves misstatements about a product that a company is developing. We see this a lot during the 1980s. That was a time when computer technology was booming, and investors were willing to pay more for a stock based upon the potential of a product to generate significant revenue in the future. It turned out that product turned out to be a failure, was not as successful, or was not even was not even technically viable for some reason. The stock price could very quickly adjust and collapse. So we see an allegation of securities fraud leveled at Apple Computer for misstatements made during the 1980s. Apple at the time was not the world's most valuable corporation. It was a newly public company that had started in a garage just a few years before. Many of you may remember the Apple II personal computer, iconic product that was very, very successful. And what Apple was trying to show is that we're not a one-hit wonder. We need to develop a new product that will show that we're a public corporation that can keep generating revenue into the future. And so what they were developing was a computer for the office, which is a larger market. It was called the Lisa. And one of the innovations of the Lisa was that it had a mouse, one of the first computers to have a mouse, which is an idea that they took from the Park Labs at Xerox, which is a company we're going to talk about in a little bit. One of the distinguishing features of the Lisa is that it had a high-performance disk drive called the Twiggy. And many of you may remember the days when we didn't have cloud computing or large hard drives. If you had a program that you wanted to run on a computer, you put it on a floppy drive that you had to put into a disk drive that would access the actual program. And so it was a real advantage to have a high-performance disk drive. And so they made a number of statements publicly about the drive, implying that it was a high-performance disk drive, and also that it was essentially finished. And you can judge for yourself. The statements they made are replicated in this slide from an excerpt from the Ninth Circuit's opinion in the case. And so they implied, well, it had undergone 3 years of research and development, and it's undergone extensive testing and design verification during the past year. And so the implication was that this has gone through the ringer. This has been tested and it essentially works. We know that it is going to work. And the reason why these statements might have been misstatements, misrepresentations, is that internally, Apple is in panic mode. There are memos going back and forth at the time they make these statements about how, they're never going to finish this thing. It has too many problems. We're going to have to delay the introduction of the Lisa by many months. Steve Jobs, who had been kicked off the Lisa project to work on something called the Macintosh, said that he had virtually no confidence in the division responsible for the Twiggy. And so given that they are saying essentially or implying that the Twiggy is essentially done in public statements, while internally there is a sense that the Twiggy is going to be a failure, there's a question of whether or not that is a securities fraud. Did I mislead investors about this particular product? And the Twiggy failed. It didn't work. It had a lot of glitches and had to be discontinued. And the stock price fell by about 20% after the failure, which prompted a number of investor lawsuits. These product sorts of cases are often controversial. And one argument here is that, if I punish a company like Apple for failing to successfully develop a product, am I punishing entrepreneurship? Am I punishing risk-taking and innovation? There's always a fire drill at the end when you are trying to complete a new complicated product. And is it fair to basically say that you're liable for securities fraud every time you have one of these products that doesn't live up to market expectations? The trial in this case led to a $100 million verdict in favor of the plaintiffs. And that sent shockwaves through Silicon Valley. a very significant settlement or a significant verdict. And that created pressure on Congress to implement various limitations on investor lawsuits involving allegations of securities fraud. They passed a law called the Private Securities Litigation Reform Act of 1995. And so while there are arguments against these types of cases, if you think about some recent examples, the Theranos case involves Elizabeth Holmes. The company claims that it has a machine that can run multiple medical tests on a few drops of blood. The product does not work, and they're using it on customers. She was convicted for criminal securities fraud just this past year and sentenced to 11 months in prison. About a month or so ago, there was another criminal conviction in the Southern District of New York involving Trevor Milton, who was the founder of Nikola, another startup company that was developing semi-trucks that could run on clean energy. And he was basically convicted because he made a lot of misstatements about the company's technology and products. One of the more infamous misstatements that was made is that there are questions about whether a prototype could be driven. To show that it was drivable, they took it to the top of the hill. They pushed it down the hill, and they filmed it as it was kind of going under the momentum of being pushed down a hill, and basically represented that the truck was driving under its own power. So these sorts of misstatements often can be the basis for securities fraud claims even now. Even though they're controversial, they are a core sort of theory that is often asserted against public corporations. By the 1990s, we see even more pressure to meet projections. By the 90s, it becomes important to meet projections on a quarterly basis. That is a sort of a dynamic that has often been criticized as encouraging short-term thinking, short-termism in stock markets. If you read the Wall Street Journal, every 3 months, every story is about, did this company meet its projections? What are its projections for next quarter? How is it doing? And the stock price can often be affected by whether you meet your quarterly projections. So one significant case that was brought by the SEC involved Xerox. As many of you know, it's the iconic inventor of the copy machine. And during the 1990s, it suddenly accelerated billions of dollars of revenue to earlier periods. And they did so in a way that violated generally accepted accounting principles for various reasons. They recognized the revenue too early. Why did they do this? Part of what this did was it allowed the company to meet or exceed Wall Street expectations in virtually every reporting period from 1997 through 1999. So we see accounting fraud here, accounting misstatements that were meant to meet quarterly projections. Now, violating accounting rules in GAAP by itself is not a securities fraud. It's not the worst type of securities fraud. And the reason for this is that GAAP is highly technical, and corporate managers often argue that we don't understand the details of GAAP, and we basically do what the auditors allow us to do. So in order to establish a securities fraud against corporate managers when there's a violation of accounting rules, you need to tie the misstatement into a broader story, a broader motivation to mislead investors in order to successfully win a claim of securities fraud. And so what was the motivation for Xerox to misstate its earnings? This is a front page story that was published during the period of the fraud. It's essentially an interview with Xerox's CEO, and he's trying to create the impression that Xerox is prospering despite competition from the digital revolution. During the 1990s, we see email become more ubiquitous. And when I'm emailing documents to my coworkers, I don't need to make as many copies anymore. And so there's concern about whether Xerox can prosper in the same way with this digital revolution. And the CEO is saying, yes, We are prospering. And the evidence that he points to, part of it is double-digit revenue growth, soaring profits. And that's what the gap violations were meant to do, to create the impression of double-digit revenue growth, when in fact, without the gap violations, the company would have reported flat earnings. It would not have reported flat growth at all. It would not have reported growth at all. And so this was the motivation for the securities fraud. This is the first time the SEC imposes a significant penalty on a public corporation for securities fraud. They fined Xerox $10 million. Some of you may know that until 1990, the SEC did not have the power to impose monetary violations for general violations of the securities laws. Prior to that, they would simply impose injunctions saying you should stop the practices that violated securities law, but they didn't have the power to punish someone for violating securities law. But it took about more than 10 years for the SEC to impose a major penalty. And I think part of the reason the SEC did this is that it saw a wave of these sorts of accounting frauds involving quarterly projections that had become almost an epidemic in public markets. And it wanted to show everyone that corporations were accountable, that they were being pressured in this way, and the companies that deceived investors through accounting misstatements would have to pay penalties because they had an incentive to deceive investors. So cases like Xerox were the foundation for the cases brought against executives at Enron and WorldCom. I'm often asked about Enron and why it was a criminal case, and I think it's worth discussing this a little bit. I think it illustrates some of the points I'm making in my thesis. As you know, a number of the high-level executives at Enron were convicted or plea bargained to securities fraud. And the interesting thing about the criminal case that I wanted to highlight was that the prosecutors, they focused on very narrow misstatements, relatively small misstatements for a company of Enron's size. Enron itself was a multi-billion-dollar securities fraud. They moved billions of dollars of liabilities improperly off their books. That created a misleading impression about the risk associated with the company. But the prosecutors didn't highlight the largest transactions in their case. What they did was they focused on very discrete transactions where they could show that top executives were personally involved in the fraud itself. And so we have a number of frauds that were highlighted in the Court of Appeals decision on appeal, $500 million, $7 million, $65 million, relatively small compared to the billions of dollars on the company's income statement and balance sheet. And so here's a particular transaction that is widely known involving the sale of barges in Nigeria. And so why did they do this? Why did they sell various barges to one of its special purpose vehicles? The Fifth Circuit appeal, the appellate decision, notes that the reason it was selling the barges, relatively small transaction for Enron's purposes, the reason why it's material to investors, though, is it allowed the company to meet an earnings target at the end of the quarter. And so we see, again, the issue of projections, meeting projections as a motivation for misstating earnings. And we see in this case, it's the basis for a criminal securities fraud prosecution against an individual. Was this a sale that involved Skilling? The prosecutors presented evidence that Skilling was directly involved in the sale. He persuaded the CFO, Andy Fastow, who was running the special purpose vehicles to take the barges, because he essentially guaranteed Fastow and LGM that he would make sure LGM would not lose money. And this is similar to what we saw with Penn Central, where there's a side agreement that makes this a sale not a sale. It's not a sale because Enron kept the risk of loss here. And so it could not have been recognized as a sale that would have allowed Enron to meet its various projections. Now, there's an argument that, well, maybe Fastow lied. How do we believe him that there was an agreement? And that certainly is an argument Skilling made at trial, but the jury didn't buy that argument. They believed Fastow, even knowing that he had incentives to cooperate. And these are the sorts of things. This is the dynamic of criminal prosecutions. We see cooperating witnesses every day in criminal court testifying against defendants, and it's up to the jury as to whether they believe their testimony or not. If you believe the testimony, then we see Skilling personally involved in this particular securities fraud. And part of the point of bringing up this example is to illustrate how hard it is to win convictions based on criminal securities fraud. You have to prove specific knowledge by individuals of particular transactions. And I expect that in the prosecution against Sam Bankman-Fried, the reason why criminal charges have been brought is that the prosecutors believe that they have this evidence. They have this evidence of his personal involvement in fraudulent transactions. And my guess as to how they know this is they probably have flipped some witnesses. They have probably gotten witnesses within FTX to testify about his knowledge. And that's the sort of evidence that we're going to see over time, this very specific evidence of the involvement of high-level executives involved in fraudulent activity. So the response to these frauds, the internal controls that are required by Sarbanes-Oxley reflect my thesis that part of the focus, the reason why we had this wave of frauds was a pressure to meet projections. The PCAOB, the Public Company Accounting Oversight Board, a regulatory body that was formed by Sarbanes-Oxley to police the auditing industry, has put forth some guidance about internal controls. And you'll notice from this slide that the thing that they highlight is meeting projections, right? We should look at significant unusual transactions, particularly those that result in late or unusual journal entries, adjustments made in the period end financial reporting process, significant management estimates, incentives for and pressures on management to falsify or inappropriately manage financial results. This is consistent with the story that the book tells, that it's the emergence of these projections, the pressure to meet short-term performance metrics that often drives this problem of securities fraud. And as projections become more prominent, important for public companies to meet, that's what justified statutes like Sarbanes-Oxley, which increased regulation of financial reporting. Another question I often get is, why weren't there more securities fraud prosecutions brought after the financial crisis of 2008 and 2009? Why were there no criminal prosecutions against the CEOs of the various banks that the government had to bail out when they essentially became insolvent? It's a tough question to answer. It's very complicated, but if you look at the sorts of cases that the SEC did bring, I think what they highlight was that it was very hard to find particular misstatements that were associated with the larger losses that drove these companies into insolvency. So one example of a significant case that the SEC brought was against Citigroup, which was one of the companies that that got in the most trouble during the 2008-2009 financial crisis. What did it do? Well, during about the summer or so of 2007, they misled investors about the extent of their exposure to the subprime mortgage market. They claimed they had reduced their exposure from $24 billion to $13 billion. This was technically correct, but also misleading because they had a total of $50 billion when you counted various obligations, contingent obligations that would kick in if the market for bonds, for these mortgage bonds, went down. They were obligated to basically to sort of buy back certain subprime assets from investors. And so that exposure was actually much more significant. When they acknowledged this later on in 2007, their stock price fell by 10 or 15%. And this was a misstatement. This was not true. The SEC brought a case, but the sanctions were fairly modest given the size of Citigroup. Citigroup itself paid $75 million. The CFO paid $100,000, and the head of investor relations paid $80,000. Very small penalties relative to what other individuals have paid, certainly not criminal penalties. And I think the basic thought of the SEC was that this is more of a mistake than a fraud. This was simply not being thorough and absolutely clear about your statements, not doing your homework perhaps before making certain statements to the marketplace. There wasn't a broader story that we could use to really link this to a severe securities fraud. Now, certainly they probably wanted to keep their stock price up, but even when the truth came out, relatively modest decline in the stock price. And so fairly modest penalties, even though these were misstatements that were made to investors. The really severe losses that came later on, more than a year later, they would have happened regardless of whether or not these misstatements were made. And I think the argument as to why there are not a lot of securities fraud cases brought was that the extent of the crisis was a surprise even to the managers of these banks, that they didn't realize it would get as bad as it did. And so it's difficult to say that somebody's committed fraud if they are almost as surprised as you are. Recall when we talked about Apple, one of the sort of the essence of fraud is that the managers know a lot more than the investors, right? Apple's managers knew a lot more about the Twiggy and its risk of failure than the investors. That's why they may have committed fraud. In the 2008-2009 financial crisis, I think the managers arguably were almost as surprised as investors about the extent of the crisis. And so it's more difficult to say that they deceived investors. I think this is a controversial point, but this is my explanation as to why you didn't see as many securities fraud prosecutions. And as the Enron slides show, they couldn't find that really specific evidence that really tied in top-level managers to specific misstatements. I think that the balance sheets of these companies were so complex that some of the managers didn't really know about exactly what was in them, and so it was much harder to find them individually accountable than the case involving case against Skilling and other Enron executives. We see the SEC innovating with respect to its various securities enforcement cases. More and more, they are not only going after accounting violations, they're going after business practices that might be misleading to investors. GE, as you know, the iconic corporation, suffered very severe losses in 2017. Stock price fell by about 80%, and the company has not really recovered since then. The SEC settled the case a couple years ago against the company for $200 million. What did GE do? It didn't commit accounting violations, but what it did was that it hid its losses through various business practices. This is what we often refer to as real earnings management. You're managing your earnings while making real business decisions. And basically what GE would do is that it saw that it had cash flow shortfalls, and so it would basically sell receivables, more and more receivables, money that it would receive in the future. While its prior practice had been to sell receivables for about a year out, they were selling receivables for about 5 years out. And this is a very risky strategy because if your business does not recover, you've basically cannibalized revenue that you're supposed to earn in the future. And so at some point, you're going to have to reveal significant losses if your business does not improve. So what was wrong with this? Well, for a long time, everyone knew GE managed its earnings. This is another front page story from the Wall Street Journal in the mid-1990s about GE's earnings management and how it smooths its earnings. And that's part of the reason why GE's stock was so attractive for a long time. Now, no big surprises, just steady growth over time. We trusted their top level managers to manage their earnings in a responsible way. So in GE's case, there were particular problems with the way it managed its earnings. It was very clear that they are doing this to meet particular cash flow projections that analysts were focusing on. They knew this. And also they knew internally that these practices were not sustainable. They knew that the true condition of the business was bad and that this is a very risky strategy. And that's essentially what made this deceptive in the eyes of the SEC. And so we're beginning to see somewhat more aggressive cases brought by the SEC directed at a broader set of misstatements and misrepresentations. Another example of this involved Under Armour. They had expectations to generate 20% revenue growth. And when they were not on track to meet this projection, they would call up their customers, ask them to take product early, and they would basically recognize that revenue, which was not sustainable over time. Interesting footnote in the SEC's opinion, they specifically say this does not make any findings about GAAP violations. And so they're highlighting that this is a potential securities law violation, even though it didn't violate generally accepted accounting principles. And this also shows the continued pressure of the valuation treadmill. It wasn't enough for Under Armour to report 15% growth or 10% growth. They have to meet a 20% target, or else their stock price would go down. ESG, Robert mentioned, ESG is an area of huge interest for financial analysts these days. And if you think about the future of securities fraud, we're seeing the SEC becoming more active in this space, bringing cases where they argue that a corporation misled investors relating to ESG risk. This was a case brought against a Brazilian energy company, Vale, just this past spring. One of its dams collapsed, caused significant environmental damage, and the ADRs of the company traded on the New York Stock Exchange and went down by 20%. If you read Matt Levine, the Bloomberg columnist, he has a running joke about how everything is now securities fraud. Whenever something bad happens at a company, there's an allegation you should have warned us about that risk, and a company is sued. And it's a criticism that has a grain of truth in some cases. I think in this case, though, I think the SEC has some pretty good evidence that Vale knew internally there was a very high unusual risk of collapse of the dam. And while it knew of this risk, it was communicating in various sustainability reports and SEC filings that its dams were safe. And so this is a divergence between the manager's internal knowledge and what they're conveying to investors that may be significant. And this could be the basis for a securities fraud claim. I hope you enjoyed this brief history of securities fraud regulation. I think the book is not just a story of securities fraud regulation, but a history of the public corporation. As we've seen the public corporation change over time, we've seen the regulatory challenges also change and evolve, and that's why we've needed statutes like Sarbanes-Oxley. And I think it's a bigger story than just about securities fraud. And as we see the public corporation change even more, as ESG becomes a greater concern, I think we're going to see different types of regulation and different emphasis by various regulatory bodies. Thank you very much. I'll stop the share now and see if there are any questions. Celia Anderson has a great question about the problem of stock options and executive compensation. And so it's a complicated story, Celia. I think the more dominant story of securities fraud is that it becomes more of a problem as we get more stock-based executive compensation in the 1990s. That's sort of the conventional explanation. And certainly there are more incentives, individual incentives that you have to misstate earnings and meet earnings projections because of executive compensation. And those were often highlighted in cases like Enron and WorldCom. Skilling and Lay, they sold a lot of stock before the various restatements of Enron's earnings. Bernie Evers of WorldCom had hundreds of millions of dollars of his stock that were used to back up loans that he had made to buy, land in Wyoming. And so he needed the stock price to stay up. And so certainly the individual incentives of executives changed. I mean, there's an argument that this is what contributed and led to the wave of securities frauds in the late 1990s and early 2000s. And I think that's true. I think that's part of the story. I don't think it's the whole story, though. And it's interesting you mentioned Xerox in particular. If you look at the SEC's case against Xerox and its executives, they don't highlight the executive compensation story. They don't highlight sales around the time of the fraud that would indicate that part of the motivation for the fraud was the individual incentive of the executive. Now, certainly they were paid partly in stock. They had incentives to keep the stock price high, but I think there's broader motivations, broader corporate motivations to show that you're beating back the competition, and keeping the stock price high is generally your job as a manager, regardless of your individual incentives, your individual executive compensation. Xerox, as a corporation, has incentives to want a high stock price, and the way you do this is by meeting projections. And so to me, the projections were an important part of the story. They're not the complete story, but I think they're a significant element of it that has not been explored as much as the executive compensation story. And even if executive compensation had changed and you're more payment is made in stock, if markets didn't focus as much on short-term performance, we would see managers doing something different, right? They may not have had as much incentive to commit securities fraud in the way that they did. And so to me, it's more about corporate projections. And you also see, some of these frauds happened in the 70s before managers were paid as much as they are in stock options and stock as well. And so that's part of the point. Part of the academic point of the book is to sort of develop a story of why securities fraud happens that's a bit different than the conventional explanation, which focuses on executive compensation. Okay, got another question from Robert Thompson. Any forthcoming litigation coming forth from the slew of SPAC market IPOs we saw last year? Yes. The SPACs are a very, very interesting example of innovation in public markets. And, part of the story of SPACs is that they become more prominent because, companies are searching for different ways of going public, right? The thought is that the IPO is too expensive. And so the SPAC gets around that IPO process. And so there was, some acceptance, I think, of SPACs because it was seen as a cheaper way of going public. And, the perception is we want more companies to go public. Now, the problem with SPACs is that, I think there's a couple of problems. One that's been highlighted, Professor Usha Rodriguez, who, prominent professor at the University of Georgia, has highlighted a lot of the conflicts of interest in SPACs, some of the governance issues that we see with SPACs. And we've seen some derivative litigation already with respect to SPACs and various conflicts of interest that I think we're going to see continuing over time. The other problem to me is a problem of valuation and, the idea that, we can value these companies based upon their private valuations, and we can trust managers to pay a fair price, a good price for private companies, because private markets have now become more sophisticated at valuing private companies. I think that that was a flaw. That was a flawed assumption because these private valuations are very uncertain. There are a lot of conflicts of interest. There's a lot of speculation in private valuations. And we often saw SPACs overpay for these private companies, and these companies have not done very well. I just read today WeWork, which failed in its IPO. It failed in the scrutiny of investment banks in that IPO process. They may be filing for bankruptcy. This is a company on paper worth close to 60-70 billion dollars. But the protection of the securities laws basically protected investors from massive losses in that case. And with SPACs, they often relied very aggressively on making projections. And this ties again to my theme of projections and how they are sort of a important way of valuing companies. And certainly SPACs aggressively use projections in marketing, various acquisitions to retail investors, and there's potential for misstatements and misrepresentations. Even with projections are protected by a safe harbor by the Private Securities Litigation Reform Act. But in some circumstances, even a SPAC can support claims of securities fraud. And so as we see the market adjusting, as valuations are adjusting, we're going to see more and more investors that suffered significant losses in these SPACs. And they're going to assert securities fraud theories against the founders of the SPACs and other people who were involved. And so I expect that we will see quite a bit of litigation in this space. And it's complicated, though, because some of the legal theories are untested because it's a little bit outside of our traditional initial public offering and public corporation setting. And so there's some complications about the way that the securities fraud laws will apply to these various SPACs. There's so many of them as well that I think that it's going to take a lot of time to sort of weed out exactly what happened, but I expect that we will see a huge amount of litigation involving SPACs. And the question is whether the SPAC can be saved in some form. I do think that it is a good thing for there to be some alternatives to going public, but I think the incentives need to be better. I think there needs to be more accountability with respect to the projections that are being made so that retail investors are not misled. Okay, I think any more questions? I think we're close to the end of our time.
Jim, this is great. Thanks so much for everything. It was a great hour. Really enjoyed it. I really appreciate also the example at the end you provided, like on WeWork, in the metrics. Like I sometimes think about community adjusted EBITDA and just the bidding, like sometimes the way people will report aspects, but just wanted to say we have real heartfelt appreciation for what you shared with us today, and really enjoyed it. Thank you.
Thanks so much, Robert. It's always great to talk about securities fraud, and as investors, it's something that you should obviously know about. It's very hard, for a non-lawyer to understand the ins and outs of the law. And if you have somebody who's interested in securities fraud, please recommend the book. It's on Amazon, The Valuation Treadmill, and I hope I try to write it in a way that's accessible to non-lawyers, and I think this is a great association to have investors educate themselves about these sorts of issues. So thank you so much for having me, Robert, and thank you to the group. I really appreciate you coming.
Absolutely. Thank you, Jim, and thanks to everyone who connected with us today. If you could, for everybody that attended, look for an event survey to follow, and have a great day. Thanks again.
Thanks everyone. Happy holidays.
Happy holidays.